Susan Hirsch, National Science Foundation Law and Science Program. And speaking from that position, and also speaking for my fellow program officer, Reggie Sheehan, who's been participating online, we are very pleased that this event is taking place, and especially glad to have a part in supporting it. I know you'll agree with me that yesterday's presentations, the discussions, the Q&A sessions were enormously stimulating. And the highlight for me from where I sit now at NSF was listening to the presentations and knowing that over the years, NSF and the Law and Science program in particular have funded multiple key strands of research that shed light on the challenges around scientific evidence and courts. For those of you who don't know the Law and Science program, we fund research that addresses law and law-like systems of rules. We fund research that advances understanding of the connections between legal processes and human behavior. Many topics are relevant to our twice-a-year calls for proposals, including governance, regulation, technology regulation, crime and violence, decision-making, many of the things you heard about yesterday, and many more topics. So I want to encourage audience members to check out our program, come to us with ideas about research and conference topics related to what we've been talking about for the past day and today, and in other areas of law and science. So that's my commercial for NSF's Law and Science program. And as part of that pitch to encourage research and conference proposals to us, I want to mention that as a general aim, NSF is committed to broadening participation in research. We're looking to involve and support a wide and diverse range of scholars and institutions, including those that have been historically underrepresented in research funding. So please think with us about how to do that broadening. We're very committed to it, and be in touch with any questions. Yesterday's sessions highlighted some very thorny problems facing scientific evidence in relation to courts today. Multiple times, presenters mentioned that these problems are not easily solved and that solutions have to engage scientists, judicial personnel, educators, engage those constituencies individually and collectively, and that culture change might be a necessary element. And my ears perk up with that as a cultural anthropologist and as someone interested in how we do really complex social change. The message was clear that significant effort will be required and that serious collective deliberation figures centrally in moving towards solutions. With that sobering challenge in mind, I want to end by highlighting the aims for this conference, as Teresa articulated them yesterday in her terrific opening remarks. The three aims bear repeating as a guide for what's needed to address the hard problems identified yesterday and for our discussion today: scientific excellence, communication, and collaboration. I'm especially glad for the collaboration between NSF and AAAS, NIJ, and the other institutions involved in mounting this conference. Thanks and congratulations to colleagues at AAAS who have been our gracious hosts. I'm sure you join me in thanking them and in looking forward to today's session. Thank you very much.
Well, thank you, Dr. Hirsch, and I know I speak on behalf of everybody here when I thank you and NSF for your support for this activity. Actually, earlier in my career, I did a lot of work with the NSF Social and Behavioral Sciences Director, so I'm quite familiar about this sort of critical and powerful role that NSF can play in cross-disciplinary research that really particularly brings together natural and social sciences, including law. My name is John Randell. In my day job, I am a molecular biologist who serves as the Chief Alliance Officer for a global genomics research consortium known as the Human Cell Atlas. But I'm really here today in a different role, which is that I'm currently serving as the co-chair on the AAAS side for a joint AAAS-ABA committee known as the National Conference of Lawyers and Scientists. This is really a remarkable committee. It was founded in 1974, which means that I'm expecting to be back here next year for some 50th anniversary celebrations. We'll see if we can organize that. Basically, ABA and AAAS both appoint several members to this committee. They each appoint a co-chair, and then we meet a few times a year with very profound support from the AAAS staff and the staff liaison at ABA, particularly the Science and Technology Law section, to examine a wide range of issues. We're available for support, for advice to both the ABA and the AAAS leadership on science and law issues. And we sort of review studies that the program staff here at the AAAS does on these issues. Of course, dates back across a range of issues over 50 years. Most recently, we've been doing putting a lot of thought into issues like climate change, opioids, AI, and so forth. So a very wide-ranging remit, which is a challenge for us and, of course, the staff as well, but our merry band does our best to stay on top of the issues and be helpful. And I should say, too, that in addition to sort of meetings such as this one, conferences, they organize judicial seminars, and this is both the AAAS program, again, advised by NCLS, as well as policy studies and other forms of activity. So again, a lot of breadth, not just in the topics we cover, but also the types of activities. So I only have a couple of minutes, and I'm mindful of Dr. Parik's exhortation that opening speakers should be profound, informative, or brief, and so I'll be brief. And hopefully a little bit informative. Just in a couple of minutes, I want to recap a little bit of what we heard across a very rich and wide-ranging series of discussions yesterday. We heard a lot about the challenges and the barriers that we're facing in examining issues related to science in the courts. Some of those were just resource issues. I was particularly struck as somebody who's not deeply involved with the court system, actually not involved at all in the court system, of the distinction between what we heard about the differences between the challenges in civil cases versus criminal cases, and that both time and money are more available in civil cases. Not that that solves all problems, but it does suggest that with more time and money, we could make some progress. But there are also structural challenges. We heard from Dr. Mnookin in the opening keynote about partisanship and epistemic competence. We also heard throughout the day about concerns over public trust in science, a relatively low expertise or low pre-requirements for law students in areas like statistics and probability, as well as just general science. And we heard from Judge Rakoff in his closing keynote about I thought this was a really striking observation myself, the lack of consistency across the legal system in how science is treated in the courts, really just not, that consistency is just simply not sufficient to even really be considered or to qualify under the concept of rule of law. So I thought that was a really striking observation as well. We explored a range of solutions. I would say that, while many of the structural challenges I just mentioned are really just societal and they're broad, we're not going to make any progress ourselves on them, but hopefully as a society we can. There are some really targeted ideas that came up yesterday that I think give some optimism here. They are targeted, but you need to have a very focused set of ideas in order to make progress. We heard from Joe Cecil about a number of ideas that have been tried and to varying degrees of success. Court-appointed experts, special masters, and so forth. We heard about the Australian hot tubbing approach, but also a cautionary note about the relative effectiveness of that approach. I think obviously more study needs to be done there. And we heard about some simple policy or practice changes, just judges being more proactive about convening hearings, Daubert hearings. We heard about changes to appellate practices, particularly regarding doing away with the abuse of discretion standard and replacing it with sort of more of a de novo review. And so I think that, that's where I think we're going to make some traction here. And so I hope we can have more discussion of ideas like that today. But I also want to highlight the role of professional societies. I think that's really important. It's one that, I've certainly thought about a lot about in my career. It came up particularly, for example, in Deanne Ottaviano's remarks from APA about their involvement in amicus briefs. And so I would love to have more discussion about that, how professional societies, other NGOs can have a role to play here in improving how science is incorporated into the court system. And I'd also just like to also make a comment about forensics, because we heard a lot about the PCAST report, obviously the National Academy report, and other activities. But I was really struck in when we were talking about various areas of forensics, about the more optimistic comments about bite marks, and it really led me to think that perhaps a productive approach here is really tackling one of these problematic techniques at a time and really focusing on that, getting it out of commission, and then moving on to the next one or the next set of challenges, rather than trying to tackle the entire problem of fixing forensics in one fell swoop. So those are just some random thoughts, hopefully a little bit informative, maybe a tiny bit profound.